Ben Azimi here, personal injury lawyer and litigator. Today I wish to discuss the difference between public property and private property when it comes to personal injury cases. Most of what I'm going to talk about has to relate with slip and falls and trip and falls in Ontario. Now, public property is any government-owned property. It could be sidewalks, roadways, boulevards, community centers, and parks. Now, different divisions within the municipality may be maintaining these types of public property. However, the municipal government owns it. Now, private property, as the name suggests, private could be owned by companies, corporations, and enterprises, or individuals. The distinction becomes very important in this matter. Now, imagine someone sustains an injury while walking on a sidewalk and they're involved in a slip and fall or a trip and fall. Now, if they find that the city or the municipality should be responsible, then ideally they have to bring a claim forward against the municipality or the city. Now, in Ontario, the Ontario's Municipal Act, Section 4410, stipulates that if an individual wishes to pursue a claim against the city or the municipality, they need to, within 10 days of the occurrence of the injury, bring that claim towards the municipality's attention. Now, what's very important to remember is that that claim needs to be written. In that claim, you need to detail the exact injuries, and you also need to detail as to what you're complaining about. Now, this written claim would need to be served and sent to that municipality or city clerk's office. Now, different municipalities and different cities have different clerk offices, and you can find those on their website. Now, what's very important to remember is some viewers may wonder, well, Ben, how about if I'm severely injured and I'm not able to bring the claim within the 10 days? What do I do then? Well, what's very important to remember is Section 4412 of the Municipal Act says no action is barred for not giving a notice, or that if the notice is insufficient, if a judge finds that there was reasonable excuse. Now, reasonable excuse is not defined within the legislation. That definition could be found in case law. Now, the courts have defined what a reasonable excuse may be. Now, for instance, Crinton versus City of Toronto is a case in which Mr. Crinton sustained injuries. Now, he brought his claim after 6 months. So the city had brought, this claim, and they wanted to dismiss his case because he didn't bring that claim within the 10-day notice period. Initially, his case was dismissed and it went to the Court of Appeal for reconsideration. And in that, the Court of Appeal decided that Mr. Crinton had reasonable excuse. In that case, it was relating to his psychological difficulties after he sustained injury and the fact that he didn't really know about the limitation period of 10 days. Now, every case is different. Just because Mr. Crinton in his case was able to satisfy the courts that he has reasonable excuse in failing to bring his claim within the 10-day notice period doesn't mean that your case will too. So it's very important to follow that 10-day notice period to ensure that later on your case is not prejudiced if you do pursue a claim. Now, because you sent a written claim to the city doesn't mean that in fact that you're suing them, just providing them a claim. Now, Ontario's Limitation Act, it stipulates that you have 2 years to sue the city. Now, it's very important that you also don't miss that limitation period. Now, when it comes to private properties, it's a little different. Now, when it comes to private properties, you don't have to deal with the Municipal Act. You will be dealing with that company, corporation, or individual. Now, private property, in instance, could be a parking lot. So if you do sustain injuries on private property, it's better still that you bring notice of that claim to the owner of that property within sufficient time so that you can secure your prejudgment interest. Prejudgment interest is something that's discussed in the Court of Justice Acts, and I won't be discussing it in this episode, but it's very important to remember, and you can talk to your lawyer or to the lawyer you intend to retain in the future. Now, when it comes to private properties, although you don't have that limitation period set forth in the Municipal Act, you still have to make sure to bring the claim or bring your lawsuit within 2 years as stipulated in Ontario's Limitation Act. Now, I hope you found this episode helpful, and if anyone has sustained slip and falls or trip and falls on either public property or private property, it's important for them to meet with a personal injury lawyer like myself, who is experienced dealing with these matters, and to have your case reviewed. At my firm, we provide you a free, no obligation consultation. Everything is completely confidential, and we review your case for free. So if you do require services, please refer to the information below, and we'll be more than happy to assist you. Thank you.